Hi class, this week we are going to discuss chapters 10, 11, and 14. Chapter 10 is about real assent. No agreement is enforceable if the parties did not enter into it, 1, of their own free will, 2, with adequate knowledge of terms, and 3, with a mental capacity to appreciate the relationship. Contracts coerced through duress will void a contract if actually induced through physical harm, and will make the contract voidable if entered under compulsion of many types of threats. The threat must be improper and leave no reasonable alternative. But the test is subjective. It's more about what did the person threatened actually feared, not what a more reasonable person might have feared. Misrepresentations may render an agreement void or voidable. Among the factors to be considered are whether the misrepresentation was deliberate and material, whether the promisee relied on the misrepresentation in good faith, whether the representation was of fact, opinion, or intention, and whether the parties had a special relationship. Similarly, mistaken beliefs, not induced by misrepresentation, may suffice to avoid the bargain. Some mistakes on one side only make a contract voidable. More often, mutual mistakes of facts will show that there was no meeting of the minds. Those who lack capacity are often entitled to avoid contract liability. Although it is possible to state the general rule, many exceptions exist. For example, in contracts for necessity, infants will be liable for the reasonable value of the goods purchased. Chapter 11 is about consideration. Most agreements, including contract modification at common law, but not under the UCC, are not binding contracts in the absence of what the law terms consideration. An act, forbearance, or a promise. The act can be the payment of money, the delivery of a service, or the transfer of a title of property. Consideration is a legal concept in that it centers on the giving up of legal right or benefit. An understanding of consideration is important in many commonplace situations, including those in which a debtor and creditor enter into an accord that is later disputed, a duty is pre-existing, a promise is illusory, and creditors agree to a compensation. Some promises are enforceable without consideration. These include certain promises under the UCC and other circumstances, including contracts barred by the statute of limitations, promises by a bankrupt to repay debts, and situations in which justice will be served by invoking the doctrine of promissory estoppel. Determining whether an agreement should be upheld despite the lack of consideration, technically defined, calls for a diligent assessment of the factual circumstances. Chapter 14 is about third-party rights. The general rule that the promisee may assign any right has some exceptions. For example, when the promissor's obligation will be materially changed. Of course, the contract itself may prohibit assignment, and sometimes statutes preclude it. Knowing how to make the assignment effective and what the consequences of the assignment are on others is worth mastering. Duties as well as rights may be transferred to third parties. Most rights, or promises, contained in contracts may have corresponding duties, also expressed as promises. Often when an entire contract is assigned, the duties go with it. The transferor himself does not necessarily escape the duty, however. Moreover, some duties are non-negligible, such as personal promises and those that public policy require to be carried out by a particular official. Without the ability to assign rights and duties, much of the modern economy would grind to a halt. The parties to a contract are not necessarily the only people who acquire rights and duties under it. One major category of persons acquiring rights are third-party beneficiaries. Only intended beneficiaries acquire rights under the contract. The rules for determining whether rights have been conferred are rather straightforward. Determining whether rights can subsequently be modified or extinguished is more troublesome. Generally, as long as the contract does not prohibit change and as long as the beneficiary has not relied on the promise, the changes may be made.